in-house counsel and my colleague, Amy Baird.
Good morning, Your Honor. Tom Patterson, Sussman Godfrey, appearing for Medallion Pipeline. And with me is Mr. Degater, whom you've met, as well as Mr. Downs from my office, and also Daniel Wilson from my office.
All right. Well, so let's kind of talk about this. I think I've read all of the briefing, but if you filed something recently, I haven't. So let me kind of ask a question here that I think is kind of fundamental to, before I even decide if I'm going to hear this today, because this was set without 3 days notice. Why wasn't this brought prior to the temporary injunction being decided? I'm not exactly, I feel like this should have been decided before, because before if there had been an interpleader before and we put this money in the registry of the court, then the issue would have been, how do I rule on the temporary injunction? Now that I've ruled on the temporary injunction, I'm not really sure that there's two rival parties to this based on my ruling. So Ms. Hatfield, why did you wait until now to do this?
Your Honor, the bank didn't have a draw request at the time the temporary injunction happened. So there was a draw request earlier in the week, last week, by Medallion. That request was not compliant with the letters of credit, and the bank issued a notice of dishonor as a result. Medallion did let us know that they planned to issue another draw notice, but that didn't happen until this Tuesday. In anticipation, knowing that
So you weren't aware of this temporary injunction or all the hearings we've had on this, and no one ever informed you that the critical issues in this case about whether or not, the temporary injunction was going to be granted. You weren't aware of any of that?
No, Your Honor, we certainly were aware that all of this was going on, but we didn't have a draw request. The draw request was made Tuesday of this week. It would have to fund by the end.
There was a draw request. You just said the first one was inadequate, correct?
Correct. There has been a draw request.
And the first draw request was prior to the temporary injunction hearing, correct?
That is correct, Your Honor.
At this point, I just don't see why this is an emergency. I don't know why I would interplead this money. We can go through the normal process but I just don't see how I could possibly, how I could even say there's two rival claimants at this point.
If I may, Your Honor.
This is Ms. Hatfield's motion. Let her respond.
Thank you, Your Honor. So there have been, from both parties, we've heard from both parties that they have an interest in these funds. So obviously, Medallion has made the draw request, but ARM has reached out to the bank and in its pleadings has indicated that it thinks that it has an ownership interest in the actual letters of credit that are underlying the funds. And so as a result, the bank views this as two parties who have rival claims or who claim they have an ownership interest.
But the court has already ruled on this issue, haven't they? Haven't I already ruled on this issue?
Well, I understand, Your Honor, that you didn't put a temporary injunction in place, but my understanding is in the lawsuit, it's still disputed as to who owns those funds. So the bank is just looking for the court to direct it and let it know. That's why we'd like to put the money into the registry of the court so that the court can make the determination who should have the money, as opposed to the bank being put in that position.
And if I don't rule on this now, then what happens?
If you don't rule, so if you don't rule on this and it's your belief that there aren't rival claims, then the bank will fund the draw request. But as we sit here right now, that's why we're in front of the court before the end of the day. The bank has been told by both parties that they have an interest in these funds. And that creates an issue for the bank, puts it in the place of having to make a decision that we'd like the court to make. The bank would like to just tender the funds and let the court decide who should have them.
Okay. All right, Mr. Patterson.
Yes, Your Honor. Mr. Downs, would you share your screen with Dallas Bank and Trust v. Commonwealth? Your Honor, there's Mr.
I'm sorry,
Downs
it looks like
that.
I just enabled it. I just enabled it.
As Mr. Downs puts that up, I'm referring you to the Dallas Bank and Trust case. And Mr. Downs, would you go over to, it looks like it's probably on page 3 of the Westlaw. You find that. There we go. So the Dallas Bank and Trust case, Court of Appeals decision, Dallas, is controlling precedent here. And there the court said in the first full paragraph, a letter of credit transaction involves 3 separate independent undertakings, one between the issuer and the beneficiary, one between the issuer and its account party, and finally, the underlying obligation between the account party and the beneficiary. No party to one contract is responsible for performance of the obligations of another contract. Thus, Dallas Bank, which was the issuer, had no duty to inquire whether American Industries, that was the account holder, was in fact in default, because the letter required only that Commonwealth, the beneficiary, notify Dallas Bank that in its judgment, American was in default. If Commonwealth's demand complied with the terms and conditions of the letter of credit, which Ms. Hatfield has just acknowledged, Dallas Bank was obligated to honor the draft without reference to the obligations of the parties to the underlying transaction. It goes down below that. Could you go to right there, Mr. Downs? American Industries and 4515 were not parties to the letter of credit, which is the case here, and could not affect the bank's decision to honor or dishonor except by seeking an injunction. Thus, Dallas Bank was obligated to honor or dishonor. And although wrongful dishonor could have subjected it to liability to Commonwealth, neither course of action could have subjected it to liability to American or 4515. And then below that, the risk that payment of the draft might have left the bank without a right of reimbursement against the account parties was not the kind of exposure to multiple liability that would justify interpleader relief. The court said in the very next line, as it had already, interpleader was improper. The petition to interplead these funds to the registry of the court here is improper for exactly the reasons that are specified in Dallas Bank and Trust. There's no, for there to be an interpleader, there has to be a right to interplead. One of the elements, as Your Honor has acknowledged, is that there have to be rival claims on the letter of credit. The letter of credit's at issue here on their face, and that's our DX 14 and 15 at page 69. You find that, Mr. Downs? They specify that only Medallion is the beneficiary. ARM is not. ARM has no claim to these letters of credit. Right up there at the top is the beneficiary. Only lists Medallion Pipeline Company. The bank's duty is to honor a proper request to draw on the letters of credit. It is not the bank's job to decide who wins. It's not the bank's prerogative to ask the court at this point to decide, whether it should fund. This is not a proper petition for interpleader in Texas. And the Dallas Bank and Trust case is exactly on point and controlling about why the court should
Ms.
not
Hatfield,
allow it.
I'm sorry, Ms. Hatfield, it does appear that case is remarkably on point. How do you distinguish it? Ms.
Your
Hatfield?
Honor,
May I
so
speak to
the-
that issue?
No, I'm asking Ms. Hatfield. It's that she's arguing this.
Thank you, Your Honor. The distinguishing factor, and it's actually the sentence that Mr. Patterson failed to read in the paragraph.
Why don't you pull it up so I can read what you're talking about?
I apologize, I don't have it in.
Oh, Mr. Downs, why don't you pull it up?
It's page 231 where Mr. Patterson was just reading from. You see at the bottom of the page, the non-highlighted sentence, and in fact, both corporations disclaimed any interest in the interpled funds. In that case, and it's actually in the court's reasoning twice, it appears again on the next page. In the court's reasoning, the reason the court found that there was no issue between two parties is because the account holder, the bank, the account holder ARM in this case, said it didn't have ownership in the funds. And as a result of that, the court then reaches the analysis that Mr. Patterson just read to you. And again, on the next page.
So when it says both corporations,
it's referring to, there were two account holders in that.
American Industries and 4515,
Yes, Your Honor.
is that what it's referring to? Okay.
Yes, Your Honor. And so as a result of the fact that there is a very big distinguishing factor between this case and the facts here, it's why the bank has discomfort being put in a position to make a decision about this, and why the bank is asking to be able to put the funds into the registry of the court so that the court can make that decision.
Your Honor, as we said in our papers to you, this supposedly distinguishing criterion is not at all. The court held that the interpleader to begin with was improper for the reasons it's said up above.
Ms. Hatfield, can you say this was cited to again about the disclaiming was relevant? Can you show me where that is?
Yes, Your Honor, it's on page 232. If you go to the next page. So.
Okay.
Right, it's the page past that, the next page past that. And it's right where the paragraph that says the pleadings also established on the right column. The court says in the second sentence, by their pleadings, the remaining defendants disclaimed all interest. This set of circumstances left Commonwealth as the only party at interest asserting a claim to the fund. Since only one claimant prayed for improved right to the fund, the court correctly granted the request.
Your Honor,
Okay.
This was relevant to the issue of summary judgment, which is, you'll see, that's where we are here in the court's opinion. After the funds were interpleaded into the registry of the court, the Commonwealth moved for summary judgment, prevailed. The account holders were severed. They moved. They sued the bank as well to say they were not responsible. But the relevance of disclaiming the interest was something that happened after the funds were interpleaded.
Ms. Hatfield, I
court
guess.
said that it was improper.
Mr. Patterson, just 1 second. Ms. Hatfield, I guess the sentence that I find concerning involving your analysis, it says, if Commonwealth's demand complied with the terms and conditions of the letter of credit, Dallas Bank was obligated to honor the draft without reference to the obligations of the party to the underlying transaction. I mean, so.
And again, Your Honor, I understand, and I read the language as well, but given that we have a party in this case who is arguing that the letters of credit themselves, not even talking about the two contracts that underlie this, but from the bank's perspective, we've got an account holder that's arguing and telling us that the letters of credit that we're going to honor are not properly in the possession of the party that should have them. And as a result, that gives the bank some discomfort about having to make decisions about which party is right and should rightfully hold that particular document.
Okay, all right. And then it goes on to say American Industries and 4515 were not parties to the letters of credit. So that's the same thing as we have here, and could not affect the bank's decision to honor or dishonor except by seeking an injunction, which was done in this case and it was denied. And so I guess, how do you distinguish that?
Well, Your Honor, because later in the paragraph, as the court is discussing the fact that the bank couldn't be subjected to multiple liability, the sentence that follows that is the one that says, because the account holder wasn't making a claim to the funds. And so the very first of
Where does it say because the,
sorry, so
it says
Right
in
there.
fact both,
neither action could have subjected it to liability to
maybe
American.
I'm not seeing where you're talking about.
I'm sorry, they're in the bottom of the paragraph. So where it says in fact,
Okay, in
right
fact,
above that, the court has said neither course of action could have subjected it to liability to American or 4515, which are the account holders. And then the court says, in fact, both corporations disclaimed any interest in the interpled funds. And so the way that I read and the way that the bank reads this particular case is that when it comes to the first element that has to be proved, which is rival claims as to the funds, in this case, that didn't exist. In our case, we've got two parties that are telling us that they're actually the party.
okay. Let me talk to the other parties now. Mr. Patterson, let me ask you a question, and this is kind of fundamental, I think, to what has to happen today. So the instruction the Dallas Court of Appeals gives me as the trial judge is, I think the key sentence here is American Industries and 4515 were not parties to the letter of credit and could not affect the bank's decision to honor or dishonor except by seeking an injunction. And then it cites the Texas Business and Commerce Code annotated 5.114B. Now, this is a fairly old case. It's from 1984, I think, if I'm recalling correctly. And so at this point, they sought an injunction, a temporary injunction. It's been denied. They're still seeking, I assume, a permanent injunction, which I can't rule on until we get to trial. What do I do at this point? Because they're seeking an injunction. They just haven't gotten an injunction. What is, and maybe we need to look at Texas Business and Commerce Code, section 5.114B. I do think
it was actually amended in 1999, Your Honor. That was the 1984 version of it. The current relevant statute is no longer 5.114. It's 5.109B. And the basis for an injunction.
Can you pull that up
Mr.
real quick
Downs?
so I can look at it?
Do we have that, Mr. Downs?
Mr. Downs is Johnny on the spot. He's going to have it. I know it.
Thank you. I share the same confidence, Your Honor.
Look at that. Is that right,
There
though?
we go. Yes, sir. That's 5.109. And in section B, it says if an applicant claims that a required document is forged or materially fraudulent, or that honor of the presentation would facilitate a material fraud, a court of competent jurisdiction may temporarily or permanently enjoin the issuer from honoring a presentation or grant similar relief against the issuer. That's the injunction that the statute now authorizes. There has been no allegation, none in this case, that the documents that Medallion has submitted.
Well,
to
let's
draw
break this
from-
down. Let's break each of these down. So there's no allegation the document was forged, correct, Mr. Howell?
With respect to whether the letter of credit is forged,
Correct.
we are not alleging that the original letter of credit that was issued by First Horizon Bank was forged.
Or that it was materially fraudulent.
We believe at this time that a draw request is fraudulent because Mr. Patterson's client has terminated the contracts. This is a new fact that did not exist at the time you heard the temporary injunction hearing. But after the ruling on the temporary injunction hearing, Mr. Patterson's client sent an email sent a letter terminating the contracts. And under 6.02 of the contract, we've talked a lot about 6.04, but under 6.02 of the contract, after termination, the letters of credit are supposed to be returned to us. And so at this time, any draw request is fraudulent, and we've asserted a demand to the bank that they not honor it or be subject to a claim by our client.
Your Honor, that's just false. That's not what 602B says. We said that in our papers to you yesterday. 602B, which we're happy to put up, in which they miscite, Can you find it, Mr. Downs? Because
Okay.
this is sort of the linchpin of their argument.
Your Honor, if I may
This is
briefly
in
be heard,
Defendant's
I would
Exhibit
appreciate just 2 minutes
18.
of the court's time.
Well, let me just, you're bringing up something new that we've never discussed, so I
Yeah.
just
Yes,
want to
sir.
see it.
This is
And I'll let you
602B.
address
I'm
it,
sorry,
Mr.
This is a transportation agreement, section 602. Remedies available to Medallion if the shipper defaults. The default here was their failure, as we put in our papers, as we discussed at the temporary injunction hearing, their failure to post the additional credit assurance that's required for the remaining term of the entire 5-year agreement. Their failure to do that. And their witnesses confirmed on Friday, they have no intention of doing that. So the remedies on shipper default, 602B1, say, and we can do this immediately. Medallion may terminate this agreement, which we did on Monday night. And 602B2, draw on any security provided by shipper pursuant to Article 8 financial assurances. And those are the assurances that incorporates Exhibit C, which specifies that ARM has to post letters of credit or something in form that would be satisfactory to us. But we may draw on any security, and here we're talking about the 2 letters of credit. It says below that, carrier, well, let me drop down. I'll show you what it is, to put this in context. I'll show you what it is they cite, what their basis is for the argument you just heard them make. In that last paragraph, you see where it says, carrier shall return the remaining prepayment deposit and credit support to shipper. That's what he's talking about. What does remaining mean? Well, to find out what remaining means, you have to look at the entire sentence. Carrier shall have the right, that's us, to set off all actual and direct damages against the prepayment deposit and credit support. That's for the entire 5-year term of this contract. Provided carrier shall return any remaining prepayment deposit and credit support to shipper. So if there's anything left, once we have covered all of our losses on this 5-year shipper pay contract.
Let me just ask before we get deep into this, because this is sounds like we're entering a whole different extensive hearing here, which is not what I understood was going to happen today. Mr. Howell, have you moved for a temporary injunction on this basis, based on this recent termination?
Your Honor, we moved for an injunction based on our termination in our.
Which was that was denied.
Yes, Your Honor. And
now you're saying there's a different basis based on this, and I'm not saying that I agree or disagree. Have you moved for an injunction based on that?
We asked for the court to please reopen the temporary injunction hearing and grant a temporary injunction based upon
this would be a
termination.
temporary injunction based on an entirely new ground that has not been brought up to the court before, based on new evidence and new actions, correct?
Yes, Your Honor. It's based on new evidence and new actions that Medallion took after your.
What I'm asking is, have you amended your pleadings to assert this new basis for the temporary injunction?
We filed a new pleading, I guess 2 days ago, Your Honor, asking the court to please accept the evidence of the new termination and ask the court to reconsider the ruling on the draw request.
Okay, so because I've already ruled on the first basis,
Yes,
which
sir.
I'm not going to reconsider that. Mandamus me, whatever you want to do. I've spent a lot of time looking
Your
at
Honor.
this. I'm not changing my opinion on that. This is a potentially new basis. I don't know that it's a good basis or not a good basis. What I'm trying to figure out is this been pled, this new basis been pled in your application for temporary injunction?
It is not a part of our application for temporary injunction.
Okay.
It is a part of.
All right. So that kind of answers my question. Then, if it's not part of your application for temporary injunction, Ms. Hatfield, all I can tell you is that I've ruled on the temporary injunction that's before me. I've denied it. That's all I can tell you. So if you decide you want to interplead these funds, I think you based on the pleadings before us at the moment, I think that's a little risky because I don't know that there's two rival claimants and there's no pending temporary injunction, but I'm not going to make some kind of advisory opinion based on a possible other temporary injunction that might get pled at some point in the future, whether it's valid or not. This hasn't been pled. You know, I can't tell you, I'm not going to rule on this one way or the other. I'm just telling you, there's been a temporary injunction. It's been ruled on. The court has no intention to reconsider the granting of that temporary injunction based on based on the first grounds. I have no idea about the second grounds, and it's not been pled. So I don't know if that helps or not, Ms. Hatfield.
Does, Your Honor, and just so that it's clear, so there won't be an order entered today one way or another granting or denying the request for interplead. Is that accurate?
Not at this point. I think we need to go through all the procedures that are, all the procedures you would do for an interpleader. So,
Your Honor, may I please be heard for just 30 seconds?
sure.
All right. First, with respect to the Dallas opinion that Mr. Patterson pointed out,
Mhm.
it starts off by saying every reasonable doubt should be resolved in favor of a right to interplead. And it also says that an interpleader is only appropriate if a stakeholder is or may be exposed to multiple liability. Ms. Hatfield has already expressed that that there have been multiple claims asserted, one by Medallion and one by ARM to the funds. In that opinion, it says 7 times that the corporation that is in our that's in our shoes disclaimed an interest in the fund. It says it in the fact, and it says it 6 more times in the analysis. And so there were no 2 rival claims to the fund in that case. Second, under Mr. Patterson's response that he filed yesterday afternoon or evening, points out correctly that these letters of credit are governed by a certain set of international rules called ISP 98. Those rules say under section 6.9 that an issuer may suspend payment when there are any conflicting claims to the proceeds represented by the letters of credit. So it stands to reason that that under the rules that apply to the agreement, the bank should be allowed when there have been multiple claims made.
I'm not, these are all great arguments. This is incredibly complicated, that all these issues you're bringing before me, and I respect that. I think there was a bit of a game of chicken played here, which was, you had the temporary injunction. I think maybe you thought you were going to win that. I don't know. I don't know why Ms. Hatfield didn't jump in before on this, and I'm not criticizing her for that, but I've had a temporary injunction. I've fully looked at that issue on the grounds that were pled. I deny the temporary injunction. Ms. Hatfield will need to make a decision if her client's at greater risk for dispersing these letters of credit or interpleading them herself based on what is before me in the pleadings before me. At this point, I have made the rulings that I can make. And so if you believe, Ms. Hatfield, that your client is better off because you think that Mr. Howell might actually plead a second grounds and that it's somehow, I haven't ruled on that. I'm not going to make an advisory ruling. If you have to make that decision today, I don't feel comfortable ruling on a temporary injunction that has not been pled, and I haven't read anything on it or hasn't been briefed to me. So I apologize, Ms. Hatfield, that's the situation I'm in, but based on what I have before me, I can't tell you yes or no, you're allowed to or you're not allowed to. You'll need to get that properly set and go forward from there. But based on what I have before you, this is what I've done. Does that make sense?
Yes, Your Honor.
You guys have anything else? I apologize that I wish I could, rule on everything that might possibly come in this case at some point in the future when it's properly pled and properly said. It just hasn't been at this point, and I'm not going to make rulings on things that haven't been properly pled and properly said. Does that make sense?
Thank you, Your Honor.
Well, I understand, Your Honor.
Yes, sir.
It's just a circumstance where the facts changed after your ruling. But I appreciate your time.
I apologize. I wish So,
Thank
and
you,
that doesn't
sir.
mean, I want to make it clear to you, Mr. Howell, that I'm not telling you can't file that temporary injunction. I just, it hasn't been filed and it hasn't been pled. So it may be a perfectly good grounds. I'm not sure, maybe, but it's just not been pled and I can't rule on it without a proper pleading in front of me. So,
And I certainly understand, and we're not asking you to grant a temporary injunction based on anything we have not pleaded. We have no right to a temporary injunction we haven't asked you for. I think the issue of whether the bank could interplead the money and put it under the court supervision rather than putting it in the hands of Medallion is something that the court could consider and allow, and it would allow you to make the decision once there's been a full hearing on these issues related to Medallion's termination now of the agreement, that you can decide where those funds go. You have seen the contract provisions that say that the funds are supposed to be returned. And so I think
I will say to you, Ms.
you can
Hatfield,
take those
that
funds under your supervision.
Ms. Hatfield, if you decide you want to interplead these funds, I don't think that would be frivolous, but you know what the law is, you know what the standing of this case is, you've read the case law, you need to make that determination. It may turn out that that was a wrongful interpleader and you may have to, you have competing risk here. Unfortunately, I can only rule based on what's before me and based on what's happened so far, not on some possible eventuality that may happen some point in the future. So, but I don't think that it would be frivolous for you to do it. It could be wrongful based on what's happened. So but I don't know that you're just going to have to make that decision. I apologize.
Just for clarity, Your Honor, when you say you don't think it would be frivolous, but it may be wrongful, you mean to interplead the funds, correct?
Correct. And again, that's kind of an advisory decision, but let's say you decide to interplead the funds and Mr. Patterson says, pursuant to Rule 13, I think this was frivolous. I can see where you're coming from. I also can see that I think the case law is probably wrong based on where you are right now. And if you have to make a decision at this point in time, based on what the status of the case is at this moment, but again, that's not a final decision. I can only base it on what's before me right now.
Understood, Your Honor.
Okay. Anything else, guys?
No, sir. Thank you, Your Honor,
Thank you, guys. You guys be
Thank you,
safe,
sir.
okay?
Yes, sir.
as well.
All right. Bye-bye.